Lesson: Limits on governmental data collection. Governmental data collection is a critical area of focus for privacy professionals, particularly in the context of balancing national security, public safety, and individual privacy rights. Understanding the limits on governmental data collection is essential for those pursuing the Certified Information Privacy Professional designation, especially within the domain of government and court access to private information. The interplay between these interests is governed by a complex web of laws, regulations, and ethical considerations that must be navigated carefully by privacy professionals. One of the primary limitations on governmental data collection arises from constitutional protections. In the United States, the Fourth Amendment provides a fundamental safeguard against unreasonable searches and seizures, mandating that any search or seizure conducted by the government must be reasonable and, in most cases, supported by a warrant issued upon probable cause. This constitutional provision has been interpreted by courts to apply to various forms of data collection, including digital communications and metadata. For privacy professionals, understanding the implications of the Fourth Amendment is crucial in assessing the legality of government data collection activities and advising on compliance. Beyond constitutional protections, statutory frameworks also impose limits on governmental data collection. The Electronic Communications Privacy Act and the Stored Communications Act provide a legal structure for government access to electronic communications and stored data. These laws establish the requirements for government entities to obtain access to electronic communications, including obtaining warrants, subpoenas, or court orders based on the nature of the data sought. Privacy professionals must be adept at navigating these statutes to ensure that government data requests comply with legal standards and that individuals' privacy rights are protected. In addition to legal constraints, ethical considerations play a significant role in limiting governmental data collection. Ethical frameworks, such as the principles of necessity and proportionality, guide privacy professionals in evaluating whether data collection activities are justified and whether the scope of data collected is appropriate given the stated objectives. For instance, the necessity principle requires that data collection be strictly necessary to achieve a legitimate aim, while the proportionality principle mandates that the scope and intrusiveness of data collection be proportionate to the importance of the objective. These principles provide a valuable lens through which privacy professionals can assess and advise on the ethical dimensions of government data collection practices. To effectively implement these legal and ethical constraints, privacy professionals can utilize practical tools and frameworks. Privacy impact assessments are one such tool that provides a systematic approach to evaluating the privacy implications of data collection activities. By conducting a PIA, privacy professionals can identify potential privacy risks, assess compliance with legal and ethical standards, and recommend measures to mitigate these risks. This proactive approach not only helps ensure compliance, but also fosters trust and transparency with stakeholders. Another practical tool is the implementation of data minimization strategies. Data minimization is the practice of limiting data collection to only what is necessary for a specific purpose. This principle is enshrined in data protection regulations, such as the General Data Protection Regulation, and can be applied to governmental data collection to reduce privacy risks. Privacy professionals can work with government agencies to develop data minimization policies and procedures, ensuring that data collection practices are aligned with both legal requirements and ethical standards. Case studies provide valuable insights into the real-world application of these principles and tools. One notable example is the U.S. National Security Agency's bulk collection of telephone metadata, which was revealed by whistleblower Edward Snowden in 2013. This program raised significant privacy concerns and led to legal challenges on the grounds that it violated constitutional protections against unreasonable searches and seizures. The subsequent legal and public scrutiny resulted in legislative reforms, including the USA Freedom Act, which imposed stricter limits on the government's ability to collect bulk metadata and enhanced oversight mechanisms. This case illustrates the importance of legal and ethical constraints in shaping government data collection practices and the role of privacy professionals in advocating for privacy protections. Moreover, international frameworks also influence governmental data collection limits. The European Court of Human Rights and the Court of Justice of the European Union have issued landmark rulings that shape the standards for government surveillance and data collection. For instance, the ECHR's decision in the case of Big Brother Watch and others v. The United Kingdom established that bulk interception regimes must be subject to robust safeguards and oversight to comply with the right to privacy under the European Convention on Human Rights. Similarly, the CJEU's rulings on data retention and cross-border data transfers have significant implications for government data collection practices and highlight the importance of adhering to international privacy standards. Statistics further underscore the impact of governmental data collection on privacy rights. A study by the Pew Research Center found that 64% of Americans are concerned about the government's collection of their personal data and its potential misuse. This public sentiment reinforces the need for privacy professionals to advocate for transparency, accountability, and robust privacy protections in governmental data collection practices. In conclusion, the limits on governmental data collection are influenced by a confluence of constitutional, statutory, ethical, and international considerations. Privacy professionals play a critical role in navigating these complexities, employing practical tools such as privacy impact assessments and data minimization strategies to ensure compliance and protect individual privacy rights. By understanding and applying the relevant legal and ethical frameworks, privacy professionals can effectively address real-world challenges and enhance their proficiency in managing government and court access to private information. Through continuous engagement with evolving legal standards and public expectations, privacy professionals contribute to a balanced approach that upholds both security and privacy in the digital age.